We at Farore Law specialize in high-value, complex discrimination, whistleblowing, and misconduct disputes. A big part of our practice is representing senior executives who are subject to disciplinary proceedings as a result of allegations of gross misconduct.
And as you know, our senior executive clients are often regulated by watchdogs such as the FCA and SRA. These individuals are at risk of permanently losing their careers and face serious reputational damage against them if there's a finding of misconduct on their record.
And that's where we come in. As litigators, we're able to scrutinize the employer's case and ensure that our clients have a fair process. Importantly, we're able to advise our clients on advancing the best possible defense to ensure that their professional reputation is being protected throughout every stage of the process.
And let's take a concrete example of one of our recent cases. We recently represented an FCA-regulated senior executive of a finance house who had been accused of breaching his company's confidentiality policy during his gardening leave. He had transferred a large bulk of data to his personal account, which the company later asked him to irretrievably delete after the cybersecurity threat had been detected. Unfortunately, his previous lawyers had done little to assist him throughout the disciplinary process and had only provided him with an aide-memoire at his upcoming hearing. So, what did we do to assist our client once he was instructed us?
Well, we took active steps to protect our client's position throughout every stage. We went on the record and required the employer to clarify the terms of the investigation because initially the scope was simply too vague. We also required the employer to provide further evidence to corroborate many of the allegations being put forward against our client. Significantly, we hosted for our client a mock cross-examination session where we helped our client familiarize with the process of answering questions and also assess the strengths of the client's defense against the allegations. Significantly, we managed to halt the disciplinary process for a few weeks to ensure that our client could attend the offices and inspect certain documents which ensured that he would be able to better understand the disciplinary allegations against him.
And although we couldn't represent our client as lawyers in the disciplinary hearing itself, because lawyers aren't able to represent their clients in such hearings, what we could do was to assist our client to draft witness statements ahead of those disciplinary hearings, which enabled him to better articulate his defence. What we also did was persuade the employer to interview further witnesses, many of whom provided useful information for our client to defend himself. And finally, what we did was to produce an Excel spreadsheet which explained why all of the data had been sent to our client's personal account, thereby providing him with a substantive defence.
Throughout every stage of the process, we kept our client's interest in mind by ensuring that he could maintain his status as an FCA-regulated individual and ensure that he could find comparable and alternative employment in the future. And that's why clients come to us. We go the extra mile to protect our client's professional reputation, and we recognize that this is the most important interest and stake in these misconduct cases.